Okay, welcome everybody to the January 16th meeting of the Highland Park Zoning Board of Appeals. Patrick, can I get an attendance roll call, please?
Yes. Scott Weisberg.
Here.
Craig Wolf.
Here.
Irene Chase.
Here.
Jonathan Trushansky. Absent Brad Zaransky.
Here.
Alexis Yablon.
Here.
And Chair Bay.
Here.
We have a quorum.
Okay, thank you. All right, I'm going to go off script here for a minute because we have two new members that I would like to introduce, or actually more appropriately give them an opportunity to introduce themselves. So welcome. I'll start with you're Craig, right?
Yes.
Craig Wolf.
Hi, I'm Craig Wolf. I guess this is my first meeting. I've lived in Highland Park now for about 2.5 years, and I grew up in Deerfield.
Okay, thank you. And the gentleman to my right is Scott Weiss, if I got that correctly.
Scott Weisberg.
Scott Weisberg. Got to add the Berg, okay.
Gotta add Berg. Yes, I'm coming from, I was actually on the Transportation Advisory Group the past 2 years, so ended my term there and kind of originally wanted to be on the ZBA, so glad I'm getting this opportunity. And yeah, I've been in Highland Park for about the same time as Craig, 3 years. So
Great.
real excited.
Well, welcome to you both. And we will begin with your first meeting. It's going to be an easy one because it's only Cal, so we don't have to worry about too much. So. All right, so the first item on our agenda is the approval of the minutes from the December 5th meeting. Did everyone have a chance to review the minutes? Okay. Appears as though everyone did. Do I have a motion?
Oh, I'll move. Motion to approve the minutes. As, do I have to say anything else? Can I just motion to approve the minutes?
And I'll ask for a second.
I'll second.
Okay, a second. Before we vote on that, I need to find out if we have enough people to
I was
pass it.
just about to ask. So, my bad, because you guys are new. I guess I should have told you to review if you were to vote on it. No. Minutes.
So I think Craig said he didn't get a chance to watch the video of the last meeting. You didn't watch the
No.
meeting, but you? Okay, so we're probably going to have to continue this.
Yeah, we have
the
to
approval
continue
till
it to the next one. Yeah.
Okay. We can't get 4 votes because Alexis has informed me that she didn't get a chance to watch it either. So I'd ask for a motion perhaps to continue this till the next time.
Vice Chair Yablon.
So moved.
So moves.
Can I get a second for that?
Second.
Okay, all in favor, please say aye.
Aye.
Okay, motion passes. We'll vote on it next time. All right, moving on to item 3, business from the public. Is there any business from the public that is not on the agenda? I don't see anyone or hear anything, so we'll move on to item 4, which is old business, and there apparently is no old business. So that brings us moving right along to item number 5, which is new business. And this is VAR-2024-00034, property address 295 Cedar Avenue. The appellant is Lindar 1 LLC. Do we have a presentation, staff?
Yes. Okay, 295 Cedar Ave. The applicant Lindar 1 LLC. The request is that 295 Cedar Ave be considered a legal lot of record. The subject property is located in the R4 zoning district, which has a minimum lot requirement of 20,000 square feet, and the subject property only has 8,409 square feet. The requested relief is from 3 code sections, sections 150, 104A, 150, 402, and 15710. To allow the subject property, 295 Cedar Ave, to be used as an independent and distinct zoning lot and legal lot of record. The code section below is what the request is based off of for the continuous ownership. This property is contiguously owned by the adjacent property, and because it doesn't fulfill the minimum lot requirement for the zoning district, it is not considered a legal lot of record, and that is what the variation to this code section is for, or that's what they're requesting. This is a Compier referral, so it came from City Council. City Council is asking the Zoning Board of Appeals for a recommendation for approval or denial. City Council made this recommendation on November 25th, 2024, and below are just kind of the authorizations and the process of how it got here. Here's where the subject property is located, on the corner of Linden Avenue and Cedar Avenue. It is a corner lot. Here's a zoomed in aerial. It is currently a vacant lot, and the adjacent property, 1089 Linden, which is the contiguous ownership, is located here to the north. Uh-oh. I hit the wrong button. Okay, we're good. Here is a street view shot of the property. It is pretty, it has a lot of bushes around the perimeter. There's no fencing or anything. It's just vegetation around the perimeter of the property. So the land area, again, is 8,409 square feet. That is non-compliant with the 20,000 square foot zoning minimum for the zoning district. The lot width is 93 feet and 93.63 feet, which is compliant with the R4 lot width requirement of 85 feet. That is, this orange line here is where the distance is taken from. And now the green area is the buildable area with all of the required setbacks on the property. In that area, if a single family house was to be placed on this property, is 1,819 square feet. And here's some neighborhood context. So the green are I got all this information from Lake County Assessor's Office. These are all of the lot areas for the adjacent properties. The green average is 17,000 square feet, with the smallest being 11,200 square feet, which is 1089 Linden. Along Cedar, the average is 15,000, smallest being 10,000. That does not include 295 Cedar with this average, but again, 295 Cedar is 8,409 square feet. And then Lincoln, the area in blue, has an average of 5,900 square feet, the smallest being 8,367 square feet, which is smaller than the subject property. And that property is located here, one north of the corner property. So, getting into some background on this property. Back in 2007, there was a proposal to build a new single-family house on this property. It went before the Historic Preservation Commission and the Zoning Board of Appeals in March of 2007. The HPC imposed a 365 demolition delay on that property, and the ZBA motioned to deny the request for the encroachments that the new house was proposing for. I could not find the denial order for this case. However, the minutes state that they motioned to deny this case, so it could have been a withdrawal or it just didn't get closed out. And then the owners of 1089 Linden Ave, William and Elaine Feely, were part of the neighborhood petition objecting to this new proposed residence. And then on November 12th, 2008, William and Elaine Feely, owners of 1089 Linden Ave, and the property owners abutting 295 Cedar Avenue, to the north, received a determination from the Community Development Department stating that 295 Cedar is not a legal lot of record. Lindar One LLC then purchased that property in 2007, demolished the single-family house that stood on 295 Cedar, and then received that determination in 2008. Now, according to Illinois Office of Secretary of State Business Entity Search, William Feely of 1089 Linden Avenue is listed as the agent and agent information for that LLC. And now, this is just a discussion on, so there was a little bit of discussion in the hardship letter that the applicant is contending that an LLC is a separate entity and should not be considered an indirect ownership, qualifying the lot as a legal lot of record. However, our corporation counsel has reviewed this information, and an LLC cannot be used to circumnavigate the contiguous ownership clause of the legal lot of record. And our determination is that this is a continuous ownership, and therefore this lot is not a legal lot of record. This application is a variation request, and it is not an appeal of this decision. So just want to state that distinction, that the case before you is a variation request, and you should be using Chapter 150 standards of approval when considering this case. Okay, so just to review, again, they are requesting relief from the legal lot of record definitions. They're wanting the lot at 295 Cedar Ave to be an independent and distinct zoning lot and legal lot of record. The board should be using Chapter 150 Zoning Board of Appeals, Zoning Code Standards of Approval. And then, since this is a recommendation to City Council, we will be drafting a findings of fact, which is just going through all of the standards and stating whether they meet that standard or not. In order to put forward an approval, they have to meet all of those standards. If they fail even one of those standards, your recommendation would be a denial. And I put in a draft findings of fact at the end. That's not staff recommendation in any way. It's just kind of a shell for you to go off of and for us to build off of. Okay. And that's it. I'm sure you'll have questions.
Yeah.
I tried to be as thorough and
one or
fast
12
as
or so.
possible.
Yeah. Okay, I guess I'll start. The lot as it's situated now had a former home on it, which was demolished prior to them realizing it was not deemed a legal lot of record. Is that
Well,
correct?
so if that home were to be demolished and bought by someone who did not own a lot adjacent to the property, it would have been a legal lot of record. Someone could have purchased that property and put a house on that property. But since the adjacent neighbor purchased the property, that's what the contiguous ownership requirement, they failed. And that is why they're asking for this relief.
So the lot is owned by the property that's contiguous to this?
Yes, our
specific-
determination is that Lindar One LLC is William and Elaine Feely, and they own the adjacent property to the north.
So if they did not end up being declared a legal lot of record, their option would be to leave the property vacant or perhaps do a consolidation with.
Correct.
their lot.
So if they were to consolidate the lots, it would actually make a conforming lot for the zoning code. Both of the lots are undersized, and with both of them combined, they would be around 21,000 square feet, which now conforms with the 20,000 square foot minimum requirement.
But that would be one lot then.
Correct.
Is the ultimate goal to knock down the now standing house and build a new house on the two parcels?
No,
Or is
that,
that unknown or?
well,
does not
so
matter?
from the zoning standpoint, if it is consolidated, that house does not have to come down. But if, I don't know what the future plans, if this were to be approved or not, I would point that to the applicant on what the plans are. I'm assuming getting a
I'm sure
legal.
we can hear more on that, but it wouldn't make any sense for them to want to be declared a legal lot of record separately if they were going to build one house on the two. They
I'm
would
just trying to
consolidate.
understand what the motivation is.
To be able to build a second house
And-
on this parcel, which was because apparently there was a house there that was already knocked down,
Got it.
so. good. Sure.
So for purposes of our discussion, we're really not touching whether it's a legal lot of record or not. We're just going to discuss whether, with the information presented, if there is enough for there to be a variance granted.
So, not quite. You are determining if this is a legal lot of record. Well, if it's a,
We're recommending.
correct, yes, you're recommending, if they're allowed a variation to the legal lot of record case. We are not here to discuss, it's more of appeal if if they are in fact contiguous ownerships. And in the hardship law, there was discussions on the LLC being a distinct entity, and therefore they do qualify as a legal lot of record. That portion is a determination that the zoning administrator, Joel, my boss, has put forward to say that no, that failed the contiguous ownership section. That section is not before you, just the fact that what they're asking for is a variation from that code section of the legal lot of record. And if, in the end, if you're saying approval, that would mean a single-family home could be placed upon that house. If you say no, then it would have to be consolidated with an adjacent lot.
I think I heard you say that if it's determined that they cannot, they could then sell that land to someone else and someone else could build on it?
No,
Okay,
if,
I thought I heard you say that.
They would either have to, they could sell the land, but nobody could build on it
Right.
because it's not a legal lot of record.
Understood.
Or they could consolidate it because it appears that the people who own the property contiguous to it
Right.
consolidate it, which then it would be large enough to be a legal lot of record to build
Understood.
like a new home on. So is that
Thank
a
you.
fair assumption?
Yeah.
So just to clarify, so if the lot was sold to somebody else other than the applicants or a related entity, just random person came
yeah,
out of
so if
nowhere,
this property would just be sold
2007,
yesterday.
someone bought the house.
Oh, so, okay, so we're saying before the contiguous ownership took
Correct.
effect. Yeah, if someone else came, so that's kind of what the proposal in 2007 was. Someone else was purchasing the property, they're going to demo
They
it.
didn't need zoning setbacks, but if you bought the lot from the previous owner,
Correct. If
submitted a
they,
building permit for a lot that, or a home that was, complied with all the setbacks.
with all the setbacks, they could
They
have
would
built
be
it.
allowed to do that, even
Correct.
though it's an undersized lot.
Correct. The section is, as long as the land had not been, it hadn't been bought and sold and like sectioned off after 1960, you're allowed to continue to be a legal lot of record and be non-compliant with the average lot size. If that buying and selling happens after 1960, then by buying and selling, I mean like sectioning off the pieces of the lot. There's multiple sections of this requirement. They just fail the contiguous ownership section, which is you're not allowed to have abutting owners when both lots are undersized.
So what was the intention of the code what are they trying to prevent by the code? Like why, it just seems strange that
It's just
a
conformance.
random person could show up out of nowhere and build a house, but
Well,
a resident can't because it's.
at that time, it was a legal lot of record because none of the neighboring owners, adjacent owners owned the property. And the land had existed like that pre-1960. So it fit all of the requirements. But when they purchased the property as adjacent property owners, it then failed the requirements and then became not a legal lot of record.
Right. No, I understand. I'm just wondering what
What the intent was, or the spirit of that.
Right, what was the purpose of that fail? Like, what was that put in the code for to prevent? Like, what was it?
Well, so
Undersized lots. I don't.
it's just undersized lots. They're
Yeah.
always trying to go towards conformance.
Right.
That's what the purpose is that
Right,
if it isn't, they would then be creating a conforming lot.
right.
So really, Patrick, just to sum up, I know we're kind of going here again and again, but I think it's clear, we need to be clear what we're being asked here.
Yeah.
The only thing that is preventing this lot from being built upon is the fact that it is owned by a contiguous.
Correct, yeah, they
landowner.
failed that portion of the legal lot of
So
record.
they could, so that landowner could theoretically sell this to an unrelated party, and they would be deemed to be grandfathered in, so as to be able to build a home on it.
So,
No.
It's kind of been tainted now.
It's got to.
If it was sold to somebody else in
Basically.
2007,
yes.
Yeah.
they would have been
it-
able to.
Okay, that's.
Now that
Since the
it's-
chain of title is on them, then it's,
Yeah, if they sold it to somebody else who was not an adjacent neighbor, they would have to go through the same
So they bought
process.
it, they're stuck with it now, basically, unless they find someone else who wants to buy empty, a vacant lot for no reason.
The other adjacent neighbor could purchase the lot and consolidate, but yeah, it's kind of, it's either get the variation approval or consolidate it.
This is actually a question for Councilperson Ross. I watched part of the city council meeting where this was discussed, and I know one of the options was well, there were three options, either not to refer this at all to us, to refer it to us for final disposition, or do what is being done, refer it to us for a recommendation. Was there a specific reason that you are aware of as to why this was referred to us only for recommendation and not for final disposition?
I think council struggled with it and, thought that, it's hard for me to, say why every single council person voted the way they did, but it seemed like, just hear to hear the case and then, for you to discuss this further, opine on it, and then, send it back to council for the ultimate deliberation. I can't speak really to exactly why everybody chose that
I just
option.
was wondering whether there was any discussion that we weren't privy to as to why.
Yeah, I think it was,
that you wanted-
it just.
You guys are going to have a second chance to
Yeah,
decide this.
I think everyone, that was my sense, that people struggled with how to see this. I mean, does it meet the standards, that sort of thing.
Does council get like a presentation on this like we do, or is it just kind of in the packet somewhere?
We received a presentation. That's what I recall. We received a presentation. You gave the, I'm sorry.
Joel Fontaine
Joel
provided the
did. Joel did.
presentation.
So it wasn't just like in the 1,000-page packet, it was someone talked about it and what's.
But it was
It was kind of both.
They actually had trouble deciding. There were a couple of votes that weren't seconded, as I recall.
Yeah.
They really did kind of struggle as to what
yeah.
to do with this, so.
So to be clear, we're not voicing our opinion on whether this rule from 2006 or 2007 sits well with us or not. We're just focused on the continuous ownership, and the corporate council's opinion is it is a continual ownership.
So one of the sheets you have in front of you, there's 8 standards. You're going to be reviewing those 8 standards and see if the variation request you have before you meets those standards. What does the hardship that they present meet the standards before you? If you can say no, then that would be a recommendation for denial. But if you do think that this property meets all of those standards, you would recommend approval.
Can we get a clarification on the petition that was included? I believe this was signed in '07, is that correct?
Yeah, I'll have the applicant provide context for that. I
Okay.
just provided it in the application materials because it's material I came across, but for the context behind it, I don't have that knowledge.
Okay. And what has been happening in the past 8 years or so? It's just been sitting?
Yeah, to my knowledge, it's just, it's the same ownership since then, and yeah.
Just another clarification, when you say the buildable area is 1,819 square feet, that's actually just the footprint. So if
Yeah,
it's a
it's-
multi-story house, it could be,
So it's just this green box. That's how much space they have to place it. So, I mean, you could do multi-story, and that would bump up the square footage of the house that you could make. So that would just be if you put this interestingly shaped house together, at one level, it could be 1,819 square feet.
okay, thank you. Any other questions for staff at this point? We reserve the right to recall you.
I'm leaving.
I know the answer to this question, but I have to ask it anyway. Is there anyone else here who'd like to be heard on this matter? Would you please approach the podium and state your name for the record, please, sir?
Good evening. Happy New Year to all. My name is Cal Bernstein. I'm the attorney for the applicant who are here this evening.
Mr. Bernstein, do you affirm or attest that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Please proceed.
Before I get to my presentation, I just want to try to respond to some of the questions that I heard. To be clear, I think the board is understanding it properly that back in 2007, if a third party would have come and purchased this property, and it's unrelated to any of the neighbor's property, this would still be a buildable lot and the house can be constructed on this property today. If the current applicant turned around, let's say they get denied, and if they turn around and try to sell the property, as member Chase mentioned, this property is now tainted because the city has made the determination there's been common ownership since 1960. So as a result of the fact that there's been common ownership since 1960 would make this an unbuildable lot, and therefore it's not a quote-unquote legal lot of record. So that's kind of the trip bag we're in. Now, with regard to the council, I had an opportunity to address the council that night. I believe Chairman Bay was there. I think he probably left before this matter was called. The council was split. There was a presentation from the community development director, Joel Fontaine. I was not given an opportunity. There was no discussion of the merits of the case. The question is, what was the process? And that was a discussion that the council had. What was the process? And the council was split pretty much 50-50, whether to send it to the zoning board for final determination or for have to come back. And so that's the reason there was a lot of debate between the council people what to do with the case, because some people wanted it to come back to the council, other people just they figured you guys were the experts and just send it to the zoning board, let them make the final determination. As it turns out, the council voted 5-2 to send it to you for just purely recommendation. And that's how we got here today.
Good description.
Excuse me?
Good description.
Thank you.
Does Joe make a recommendation, or does he,
No.
he's, like Patrick doesn't?
He doesn't call balls and strikes. He just gets up there and tells them what he is. And again, what the discussion at the council was about the process. It wasn't about the merits of the case. This property is a very interesting property. A home was constructed on this property in 1924. It actually was a Van Bergen home, which Van Bergen's a significant architect in Highland Park. And a house was there continuous all the way through 2008. In 2007, the applicants, Lindar One LLC, purchased this property for $380,000. That's a very important point. They spent a lot of money on purchasing this property thinking that it's a buildable lot. Now, the city code, and I'm going to come back to this in a little bit, but the city code defines what an owner is, and that's section 150.202. And the code defines an owner as the legal title holder, which is, in this situation, is the LLC, as well as holders of any equitable interests, such as trust beneficiaries, contract purchasers, option holders, lessees under leases, having unexpired terms at least 10 years. That's what the city code defines an owner. It doesn't define an owner as someone who's a member of an LLC, but it does kind of hint at what they think what an ownership is. And the reason I'm going into this is because it provides context to as we go forward and address the standards a little later. As Patrick noted, in 2008, the house was demolished after a delay. The owners now intend on building a new, modestly sized, single-family home on the property. And as the chairman noted, there's roughly about an 1,800 square foot building pad, or building envelope for this house to be built on, which if you do a two-story house, roughly you can build a 3,000 square foot house on this property. I'm not going to go into the section of the code with regard to the contiguous lot ownership. Patrick covered that. Unfortunately, I'm old enough to know kind of why that ordinance is in place. That ordinance dates back to the 1990s. And it was put in place similar to when the lakefront overlay zone, which I'm sure some of you are familiar with, which was put in place. And the purpose is that there was a lot of tear downs being done on East Highland Park. And what the council at that time was trying to prohibit what they were calling back in the 1990s McMansions. And what they're doing is they were subdividing properties and creating additional lots, increasing the density and building basically maxing out the FAR on those properties, the floor area ratio, and building as big a house as possible, hence the word McMansion. And so the council thought at that point is, for example, like in the lakefront overlay zone, they made it impossible to subdivide unless you create a 40,000 square foot lot. Even though the underlying zoning is R4, which is 20,000, they basically upzoned it so that to discourage the construction of McMansions. Same with this ordinance. This ordinance really dates back to to prohibit people who have these non-standard lots from subdividing property out and then creating additional lots that houses can be built on. Now, the city has offered two theories on why this is considered the contiguous lot ownership ordinance applies to this. The first is what is currently before you, and I have a copy of the city's determination, and I apologize I did not include this in the packet, but I went back to my office tonight and made copies. You can circulate it. It's an email from Patrick Hoffman to myself dated April 18th, 2024. And what the email says, and I'm going to just read a portion of it into the record, it says the Corporation Council has concluded that this 295 Cedar has been held under common ownership. Therefore, it is not considered a legal lot of record. As the property owners of 1809 Linden are the beneficiaries, that's a very important word, the beneficiaries of the of Lindor 1 LLC, that is considered indirect ownership, does not comply with the legal lot of record definition in 150.202. And so therefore, the property owner cannot avoid the contiguous lot ownership by holding one of the lots through an LLC. And I'm going to circle back to that word beneficiary. I don't know how many of you are lawyers, but there really is no such thing as a beneficiary of an LLC. You have members, you have managers. The city's corporation councils have made a determination that the applicants, the neighbors, are a beneficiary, which is not actually a legal term. A beneficiary, I actually looked it up, what possibly where a beneficiary come into with regard to an LLC is, let's say someone's a member of an LLC, they die, well, their heirs are considered the beneficiary of that share of the LLC, of that membership interest. But there is no such thing as a beneficiary of an LLC. So we believe that reasoning is flawed as you look at we'll look at what an LLC is. Now, under Illinois law, a limited liability company, which is an LLC, is a separate legal a separate legal entity, distinct from its members and from its managers. So when you're holding title, the title is being held in a separate legal entity. It's not the same thing as the members and the managers. This property was purchased by the LLC back in 2007. The real estate taxes have been paid each year since by the LLC, and it was purchased in an arm's length transaction again, as I mentioned earlier, for $380,000.
Gail, may I?
Yes.
For a second, because
Sure.
there's so much going on here that I'm going to lose it if we,
Yeah, sure. You don't have to take anytime.
Yeah, I get what you're saying, and certainly most commonly a beneficiary is, or beneficial interest is in conjunction with a trust. So there wasn't any trust here. So I don't know who called members of an LLC are not beneficiaries. They're like you said, either members or managers.
Yes.
But the question, if you're asking us to go against what the corporation
I'm not asking you to do
council.
that. I'm not asking you to do
All
that.
right, let me just, so let me then ask you what the distinction is. Why is there an important, so if he had said the property owners are the members of the Lindor LLC, would that make a difference?
Well, if they took that position, but again, if you look back, as I mentioned where I started tonight, we look back at how the code defines owner, the code does not define owner as a member of an LLC. I'm going back to section 150-202, which says is the legal title holder and any holders who have an equitable interest, which would be a beneficiary, such as trust beneficiaries, specifically set forth in the code, contract purchasers. Many times you have contract purchasers becoming from the ZBA before they purchase the property, trying to get relief. They have an interest in the property, and so they, under the code, that's considered an indirect ownership interest. Option holders, if someone had an option to purchase the property, they have an interest in the property as a result. Lessees under a long-term lease, they have an interest. So what I'm saying is that even if they had, if they meant to say, instead of beneficiaries, they meant to say member or manager, but if you look at 150-202, it doesn't really say that. It doesn't say that that's an indirect interest. Sorry,
But doesn't it also, but that's not a closed set, because don't they also have language at the end saying, or, I can't remember what the language is.
And the like, it says
And the like. So there is something out there.
Yeah, I think that, we have a very, I'm trying to be generous. very competent corporation counsel, and they've done an excellent job with writing our code, and they're usually pretty clear in what their intent is. And they have that catch-all and like, I think it's a stretch.
Regardless of all that, and this is kind of just, it's splitting hairs to a certain extent. As you said, we have a very esteemed corporation counsel,
Yes.
who I believe I heard somewhere gave the opinion that the Illinois Corporation Act, or the LLC, it cannot be used to circumvent the zoning law. So how would you?
Well, we're going to get to that when we address the standards.
Okay.
And then going back to 2008, this letter is actually included in your packet tonight. It's a letter from Jason Berry, who.
Can I interject?
Yeah.
I know there's not anyone else here, but I have to announce that this is available to anyone in the public who would like to view it. And I will be posting it in the packet after this meeting is complete.
I'm looking for the.
Addressed to the thousands of viewers at home.
So there is a memory, there's a letter that I included in now I can't find it, from Jason Berry from 2008. And the letter is dated November 12th, 2008. And the reason that the city determined in 2008 that this was not a buildable lot, this one is actually more distant from what we are here today. The letter states that due to the recent transfer to a trust in which you are a trustee, the 295 is no longer separately developable. So we did a track search, and this property was never held in trust. So this letter from 2008, it's even further remote from what the facts in this case are. So under both theories, it's a legal stretch to determine whether this property is it's buildable. Now, I think this was pointed out earlier, and I'm going to repeat myself, is that if a third party would have came in 2007 and purchased it, then it could have been, it's still legal out of record and it's buildable. This, and we're going to talk about this when we talk about the standard, this is actually, and if the city's correct, let's just say the city's correct in their interpretation and there's contiguous ownership, then the ordinance basically creates a discriminatory effect because it's treating two classes of people differently. It's treating someone who lives next door differently than a third party. And that's one of the standards we're going to look at when we talk about the standards here is that, again, it's not fair. We have someone came in, purchased a property for $380,000. There's this determination if it's legitimate or not, and whether it would withstand, review, but it's treating that person differently than everybody else in Highland Park. And the question is that discriminatory? Is that fair? We'll get back to that when we talk about the standards. So I think we're ready to talk about the standards. So the bottom line is that the owners are here trying to ask this board to allow them to build a replacement home, to replace the home that was previously there on this property. Now, let's look at the standards.
Actually,
Yeah, before we go to the standards, I'd like some factual, first I want
Yeah.
to recognize Vice Chair Gablin has some questions.
Well, in terms of facts, in 2008, when the house that was located on that property was torn down, it was owned by Linder,
The
correct?
LLC, correct.
The Linder
Yes.
LLC, and Linder LLC tore the house down.
Correct, and that was before they had the determination that the city felt that they were the trustee of a trust that owned the property, and therefore it was a non-buildable lot. The city made that determination in November, the house was torn down earlier in the year.
Can you clear up for me, because I'm having a little
Yeah.
trouble factually following this. At one point, I read something where the owners, before they were owners, objected to this being declared a legal lot of record.
Yes, no, they did not.
I thought they were part of a petition.
No, the application back in, the application back from 2007. Now, if you looked at the minutes closely, you would have noticed that there was a member of the zoning board at the time named Bernstein, and that was me.
Never heard of him.
And that was me, and maybe lucky for me, I was not at those meetings where this matter was considered, so I really have no personal knowledge of what happened there. But if you looked at the objection letter, the issue in that case was that the owners of the property were looking to build a very large house on this property, asking for all kinds of zoning relief. This was before Lindor purchased the property, so there was no contiguous lot ownership issue. It was considered a legal lot of record. And I reviewed the objection letter, and what they were objecting to is that what was being sought to be built there was a house that had 5 bathrooms with 3 on the second floor, and a house that would have a large playroom on the second floor. In this situation, the applicants are not looking to do that. They're not looking to build a McMansion on this property, and that is what, and that's really telling, and I'm glad you brought that up, because back in 2007, when that application and people were objecting to the actual house that was being proposed to be built, I counted 32 people signed that letter, that petition to object to that house being built, such a large house on this lot. I'm looking at the room right now, I don't see anybody. I don't have a petition in front of us with anybody signing it against what they're doing. So I think you can surmise from that is that the neighborhood is not against the fact that this is a buildable lot. The neighborhood's against building a 5-bathroom house with a large playroom on the second story and asking for all kinds of crazy relief from the zoning code. I think that's what the neighborhood was against.
So to put this into context for me, and I apologize if I'm being a little slow on the uptake here.
Yeah.
So what are the people trying to do? They live in a house that's on property contiguous to this lot, correct?
I would say the members of the LLC live in a house contiguous to this property. Yes.
Okay. So I'll take that as a yes.
Okay.
So are they looking to stay in that house and build a new house and sell it to a third party?
Well, I mean, the intent is they're here tonight to speak for themselves, but my understanding is their intent is that they would like to purchase the property from the LLC and build a retirement house for them on this property, a much smaller house.
And do what with the existing house?
Then sell it. It'd be 2 lots, 2 houses.
So they're, in essence, want to move next door?
Yes.
And sell their existing house?
Yeah, exactly.
Okay, that kind of puts things in context for me, thanks.
And Cal, since
Yes.
you just brought it up, who are the members of the LLC?
Currently, it's the 5 of these who are here tonight. But that's actually a good point. When the property was originally purchased, there was actually another member to the LLC who was subsequently bought out. So there wasn't, at the time of the purchase in 2007, there wasn't the same contiguous, all of the members were the same, living next door. And there was a third member of the LLC who, what year was that when they bought out?
2008.
That's right, it's not too long, they moved out, and then they sold that other interest. So at one time, there was 3 members, now there's 2 members of the LLC.
Does this meeting require the same notice that a typical?
Yes. And in fact, I sent it out twice, because we were supposed to go in December, and we continued. So we actually I've sent out the certified letters twice. I provided staff with the receipts showing that they've been
I
sent.
just didn't know if a council referral is the same sort of notice. but
Yes,
Thank you for
the
clarifying.
exact same notice. So now, could I go to standards?
You may.
Okay, thanks. Any questions before I hit the standards? Okay, the first standards regard about getting a reasonable return. Usually sometimes in some of these cases you struggle with that. Well, here you have a situation where someone bought a property for $380,000 that if the variance is not granted is basically worthless. It really has very little value. It only has value as maybe being, as was pointed out earlier, as being assembled with another piece of property, or in the alternative, just remaining fallow and vacant forever. Because without this determination granting the variance, this is not a buildable, and they will not get a reasonable return for the $380,000 that were spent purchasing the property in 2007. The hardship is that without receiving a variance, that they will not be able to replace the house that was previously there, that was removed in 2008, and without being able to replace that house, it creates a hardship for the owners because they purchased the property again at fair market value of $380,000, and now they're being told that the property is unbuildable. Furthermore, what other aspect is the lot is undersized and unbuildable without obtaining the variance. And then there's the discriminatory effect. As I mentioned it earlier, that's one of the portions of the hardship, and that's in, where's the code section? Patrick, do you have the standards handy by any chance? I have it right here. It's actually standard number 3, that the particular physical surrounding shape, and that's this situation, is the shape of the lot, would result in a particular hardship upon the owner as distinguishes from a mere convenience. If the strict letter of the regulations were carried out, and it's really the application of the zoning code to the subject property has a discriminatory effect. And I submit that the fact is that a third party could build, but they can't build, basically creates a discriminating effect from the application of the zoning code. The other standards really don't, this one doesn't apply regarding the detrimental public injuries to other properties. Well, obviously there's nobody here complaining about that. Will not impair the adequate supply of light. There's no structures being proposed at this time, so that doesn't really apply. And then there's whether this will alter the essential character of the neighborhood. Actually, this is a very important point. The lot is located at the end of the block, and as Patrick noted, 90% of the houses within this area are located on undersized lots. So there's really nobody complying with the underlying zoning of having a house that's on a 20,000 square foot house. And so by not granting it, you're basically altering the essential, you're not altering, we're back up a second. Granting the variance will preserve the essential character of neighbor because it's putting a house where a house was previously located. And it is, again, as Patrick noted, this is not the smallest house in the area that has a house on it. That will have a house on it. There's actually one that's smaller. So it's, again, this is how that area was developed. As I said earlier, we started off, there was a Van Bergen home on this property. This was an historic area. I mean, this was a house that this area was developed this way with small lots. And that's kind of what we're just asking to be able to replace a house on a small lot as this neighborhood evolved back in the 1920s and was created, because there was obviously an intent to have a house on this property. So in sum, and I'm sorry to be so long-winded tonight, but this is a little bit more complicated than normal. We're asking for the right to build a replacement home. We're asking for the right to get a reasonable return on a $380,000 investment. We're asking that you don't allow the code to be punitive and have a discriminatory effect on the applicants and treat them differently than if someone else would have purchased this property. And we're asking you to basically apply the standards and find and recommend to the city council that it meets the standards and a clear hardship exists. You cannot get a reasonable return from the investment made into the house, and that there's a discriminatory effect if you strictly enforce the terms of the code, so that you would find and recommend to the council that to allow this to a variation from the contiguous lot ownership.
You've used the term discriminatory effect on several occasions.
Yes.
But there really is no discriminatory effect anymore because nobody can build on this lot. So they're not being discriminated, you know, if the discrimination was removed, if you would.
Yeah, it's currently,
once the lot-
but it's back in 2007.
There's no distinction between them and anybody else at this point.
Yeah, now,
Nobody
at this
can
point, but so if someone came in and wanted to build, they sold the house, they sold the property. They would come in for the exact same variance. And so the discriminatory effect is that it's being applied retroactively to 2007 when the lot was purchased. Because if at that situation, if there was another party purchased the lot in 2007, we wouldn't be here tonight. You'd be home watching TV. You wouldn't be here because this is the only item on the agenda. We're only here tonight because they're strictly enforcing the code, you know, tenuously, as I mentioned earlier, as we looked at the context, but they're tenuously applying the code that there's continuous ownership, and if there's someone else would have bought it in 2007, we would not be here today.
Is there a house on the other side of the lot?
Yes, there is.
Could they buy it and build it?
No.
In 2007. I guess
Right.
No, then.
But I'm
I will tell you this, I'll tell you why, and I'm going to be completely honest about that, is that the other party, the third party to the LLC was the owner of that property. And so if you're going to take this, that property, that owner sold and moved in 2008. So if they sold, if that property, has the same issues that we have.
Speaking of LLCs again, Cal, if I were to call you and ask your esteemed legal advice and say, I'm a member of an LLC, might be some other members, or I might be the sole member, and this LLC owns property, and I'm a member of the LLC, do I have a proprietary interest in the property?
No. No. I don't know define what proprietary means.
Well, it's one of the code one of our zoning code that we have to interpret. So how would you define proprietary interest? Somebody who has an ownership interest in the property.
Well, in this situation, it's whether it's a direct or indirect interest.
Okay, but that's.
Which section?
Well, I'm reading, it's our standard, one of our standards that we have to see that you've met, is that the alleged hardship has not been created by any person presently having a proprietary interest in the subject property. Well,
All right, so is it created by them, or was it created when they found out after demolition that?
I guess we need to determine.
Yeah,
I
that's,
think that the
What if
hardship
this is an
is.
SPE?
Yeah, I'm sorry.
I mean, is this an SPE? Does it do anything else, or is this a special purpose LLC just for owning this property?
Just for owning this property. So it's.
Is it pass through?
Excuse me?
Is it pass through? I mean, does the LLC, that's beyond what we really need to know, so never mind, I withdraw it.
I don't have the information.
Yeah, okay.
Well,
But.
would you like to share your opinion as to whether a member of an LLC, an SPE LLC, has a proprietary interest in property?
I would think they would, because, and if it's an SPE and it's just for owning this property, and if they pay taxes individually on whatever income comes in from it, I would think that they would have a
But there's no
proprietary
income
interest.
from a vacant lot, and there's expenses because the LLC has been paying the real estate taxes on an annual, and the insurance on the annual basis. So to answer your question, no, I don't believe they have a proprietary interest. That gets to the whole context about how we got here.
It does.
Yeah.
Absolutely
No,
does.
it's,
Any other questions for Mr. Bernstein at the present time?
I recognize this is a tough case, and I think, I appreciate, and I'm
As
sorry.
Vice Chair Yavlon pointed out, it's like a law school case.
it is.
It's actually, and actually, this is the only commission in the city that is like a quasi judicial, because you have, on most of your cases, you have final determination rights. I mean, the only appeal rights is not to the city council, it's to circuit court. So this is kind of like, it's rarely you get cases like this, and it's really purely, but this is, you kind of are acting like judge and jury in this, and making interpretations of law. And I appreciate, I understand, and I hope I was clear. If you have, I tried the best to try to explain this, but this is obviously a little ordinary than whether you should put a 2-car garage or 1-car garage on a property. So I appreciate listening to it.
And to be clear, as an example, if every one of these was met except for one,
Yeah, it's all or none.
And I also leave you again, there's a 300, one of the things we talked about the council, and one of the reasons why the council wanted this to be considered is that obviously the fundamental fairness, the fact that, they bought the property for $380,000. And basically, if the determination and the variance is not granted, that almost constitutes that you're basically taking that value, and you're basically making this property worth significantly less than what was purchased back in 2007.
Sorry, one last question.
Yeah.
Since in 2007, it was objected because it was going to be a big property or a big building.
Yes, that's my that's my review of the
Does
record.
there have to be some sort of like guarantee that it will be built kind of as said? Because if it was granted and then the owners or the LLC decide they wanted to build it bigger, then it would kind of go against the original petition, which would.
That would go back to the zoning board.
That would go back
It'd
to
go back to the zoning board, and then
We
you
could
could.
ask for variations to, otherwise it
Yeah.
has to be in compliance with the building code and the zoning.
If let's say they build a house and they can't fit within that footprint, and they ask for they could come back to the zoning board at that time and ask for, they could ask for relief, but they're not going to ask for relief to build, a large house that was previously proposed.
You'll see this again in your 8 years.
But sure, yeah.
Yes, so,
Don't put your
In-
folder down yet, Mr. Burns.
Okay.
Don't take.
I was getting away.
yeah, I wouldn't bother. In 2008, when they received the letter from the city,
Yeah.
and it was misclassified as in the trust, what was their response? What happened next?
I don't know, I didn't represent him back then, but I don't remember what you did at that point?
Well, Cal, if they're going to be
Yeah.
talking, we're
Let
going
me just say.
You just said the letter didn't make any sense.
I mean, I think at that point, it just made no sense. They just didn't really pay attention to it, and they kind of ignored it. And they weren't sure what they wanted to do with the property at that point, and so it's laid fallow since 2008.
Anything else from Mr. Bernstein right now?
Wait, one last question.
Sure, as many as you want.
So when they bought it, if at the time they were informed that they can't knock it down because they can't rebuild on it, then they would have kept it and rented it out, or what was
I think you just answered your own question. I mean, they would try to preserve the value. I mean, if they.
Or they would have rehabbed it somehow the
Right.
problem is they knocked it down. So.
These are guesses.
Right, yeah, I think that's an important part of it.
To me, the whole question is
Could you-
proprietary interest.
That's the reason I went through the whole,
Yeah.
the whole context of how we got here, whether it's indirect or direct ownership, and whether it's, and whether the trustee of a trust, as in 2008, which clearly a trust was never in ownership of this property.
I sense a question from Member Chase.
No, not yet, I'm formulating
Not yet,
it.
okay, we'll wait.
But it's
All
coming.
right, any other questions specifically for Mr. Bernstein right now, before we discuss anything?
Thank you.
Okay, all right, thank you. Anybody else here who would like to be heard tonight on this matter? No?
I guess I just have one question for the board, for one of my attorney colleagues, if you could enlighten me. So can I ask?
No, I was pointing to.
Okay, so if someone did have a proprietary interest, right? How did they cause the hardship on themselves?
If they did, how did they?
Like, yeah, how did they create the
Because
hardship?
that's one of our standards.
That's, yeah.
Right.
Well, that's one of the things I think we need to discuss. And one thing I'm struggling with, and so maybe the board can help me, is that I don't think we can or should go up against what Corporation Counsel said. And it sounds like Corporation Counsel may have chosen, the words may not be chosen well, but it sounds like they're saying that there is continuous ownership.
Right, and that,
And
in that the zoning code should not be circumvented by doing any type of legal, acrobatics, so to speak.
And I'm wondering if we need to go back to Corporation Counsel and get a better definition. Because I don't know that we can go against what Corporation Counsel, that's the spirit of what Corporation Counsel said. I agree the words are not quite what you would choose. I would refer to someone with an interest in an LLC as a member.
So
Or
to
manager.
clarify, This is the part that's a little sticky and messy.
Yeah.
You're not going against Corporation Council in any way. The contiguous ownership that's the determination that's the city has determined. And we say that yes, this is contiguous ownership. They are just asking for a variation from that, why am I blanking on the word? Requirement, sorry. So just because you think that they do meet the hardships of it, that doesn't mean you're going against Corporation Council.
It does in a sense because of the proprietary interest standard. So if Corporation Council has determined that, call it what you will, that the owners of the property had a proprietary interest in that caused the hardship, then
What if
Yeah.
we were to refer this back to corporate counsel to make a judgment on the phrase?
why don't we, I'm going to just preserve order here because
Okay,
that's part of what my job is here. So we're going to, since there's no other questions right now nobody else wants to be heard, we're going to start by polling the board, and I don't think it's fair to start with this one with a new member. So Member Chase, you kind of began to give your opinion, and I appreciate you continue.
I'm struggling with the, since we have to find that all the standards are met, I'm struggling with the first part of the, I'm trying to find exactly where the language is, that the proprietary interest.
Do you mind if I interject one more time?
Not at all.
Yeah.
So I know that we're stuck on one item, and because it's a very important item, if we don't say yes to this one item, you would send a denial. However, there are 8 items. Just because you are sending a recommendation of denial to City Council, that doesn't mean that necessarily that will happen. If you think that 7 of the items they do meet, but this one item you say they can't meet it, that doesn't necessarily mean that this will be denied at City Council. They don't have the same standards as you do.
Well, or to carry forward with what one of our new members said, that perhaps City Council will decide that they need to get a more definitive opinion on the proprietary interest.
And that could,
which is-
and that
so
could
that's
happen.
an excellent point, actually. That could be-
So
in which case, I'm glad we're sending it back to City Council.
yeah, so you showing this mix of emotions on it isn't necessarily a bad thing. It's just be thorough with what you're thinking.
Okay, thank you, Patrick.
So-
Member Chase, are you still going, or?
I'll leave it there. I'm just saying, I'm struggling with that because I'm not sure, that's the standard I'm focused on, and maybe we can agree to disagree, but I'm not sure that I can say that it wasn't created by any person presently having a proprietary interest.
Okay, thank you. Okay, we're going to move on to Member Weisberg.
Yeah, so back with the same standard. I think that they clearly have a proprietary interest, but I'm not really sure it's been created by the LLC. For instance, if before they tore it down, there was like a memo from the city saying, by the way, you're not a legal lot of record, then obviously they created it themselves. But if, it seems with a year delay, right? So if everyone knew it was going to be torn down, if there was no notice given, that they originally thought that their LLC would have been separate, so it's continuous ownership. If no one informed them in that whole period of time that, hey, by the way, you shouldn't knock this down because you can't be rebuilt, does that then alleviate that part that ideally they created it because they bought the property and knocked it down, but does that get a pass on that since they weren't informed in a timely manner to then, preserve because if they were, and then they still tore it down, then that's on them. If they were told and then left it, that's what a reasonable person would do, right? They would have left it if they knew for a fact that they couldn't tore it down, so.
Okay.
That's kind of where I think the rest of the standards, pretty much pass, but I think that they could get around it there by saying that they didn't create it.
Okay, thank you. Vice Chair Yevlon?
Yes, thank you, sir. I'm
Sure.
chomping at the bit a little bit today.
No.
No, because I sat here and made notes and different sheets to really kind of untangle this. And first, I'd like to address the email from Patrick and to point out that he is not an attorney and that while he obviously did not use the correct legal word, I think he gets a pass and should not be penalized for that. And that this is not a note from Corporation Counsel, this is a note from the city planner. And I'd like that to be stated. I think there's lots of little problems that make it impossible to grant this variance, including starting with the very last standard, which is the proposed variation is in harmony with the spirit and intent of the zoning code. By ignoring the legal lot of record issue, I think that is going against the spirit of the zoning code and kind of being a little, sorry to the court reporter for having to write but, so that's my first problem that I see. The next is, as the only owners of the LLC, yes, if you are an owner, you now own personal property versus real property because the trust is owning the real property. But I'm going to use the word hinky. It all gets a little hinky here, in my opinion. And the fact that the owners of the LLC tore down the house in question, and the hardship is now that you can't build a house, I think that's very difficult to overcome in its own right, because that seems to be the basis of what's going on. I do not see it to be a unique challenge that the city is not allowing something, that the city doesn't allow a lot of things, and that's not enough of a reason for someone to come in front of us, is the city doesn't allow it. Like, I want to build a skyscraper and the city doesn't allow it. I think there's a lot of painting going on, and that multiple standards have not been met here. And it's not just the proprietary interest, it's who created the hardship, it's being the spirit of the intent. We talk about value in terms of purchasing the property for $380,000. It was an arm's length transaction, as you said. That was the value then. There's no place where it says in the code that things need to maintain their value, unfortunately. I mean, that's not part of it. I do not believe the standards have been met at multiple levels. And also, I think it's impossible to address some of the standards in either case because we're talking in generalities. So I just think there's a lot of problems going on here.
Thank you. Member Wolf.
I think that there's some assumptions being made regarding why they tore down the property. We didn't get that detail, but I think, that is, I don't want to make an assumption as to why they tore it down. Proprietary interest, it just feels like, for me, that's the biggest challenge I have, and I'm not comfortable ruling or giving an opinion on something that I don't know. I know enough to know what I don't know, and I would ask corporate counsel for an opinion on that. Otherwise, I find that all the other standards are are reasonably being met here.
Okay, thank you. Member Zaransky.
I think this has just been way overcomplicated by too many attorneys, too many years, too many planners.
You never have too many attorneys.
And this argument's been posed so many different ways to try and get stuff done that it's kind of complicated the whole thing and backfired, and it just caused too much confusion. From a practical standpoint, I think the lot should be buildable. I think that it makes sense. To your point, Cal, this neighborhood was designed with undersized lots. There's lots that are smaller in the neighborhood. There's lots that are basically within, a few hundred feet of this, of the size of this lot. I could get there on the standards. I think, frankly, that the applicants are, in a sense, being mistreated. It doesn't seem right to me that an indirect or a third party could have bought this in 2007, wrecked the house, build whatever they want within, conformance to the zoning code. But since they're the next door neighbor, they can't. That's what bothers me most. And I would think that between Corporation Counsel and Council, there would have been a better path to solve this and not, deal with it this way. So I would be in favor of making a recommendation to Council to approve the variation. However, making sure they look at the certain things that, the board has an issue with. But in my opinion, I think, again, I think the applicants were mistreated by the city, and I would be in favor of, supporting a variation to build on this lot.
Okay, thank you. Okay, I agree with a lot of what has been said, and I disagree with some of what has been said. I think we're obviously, candidly, I think most of the standards have been met, and like Member Chase said, I think I'm kind of stuck, and I think Member Wolf as well, kind of stuck with the proprietary interest standard. And I think it's hard, and I also think that Member Weisberg raises a good point as to whether or not what the intent was or what the knowledge of, because we're talking about Corporation Counsel having said that we shouldn't be using other mechanisms to circumvent the zoning code. Well, I think that implies a certain amount of intention, which I'm not sure was here or not. And I'd like to really delve into that a little bit more and find out whether that's, what Corporation Counsel's recommendation would be as far as, whether that would change the, what we would want to recommend. So having said all that, I will ask Patrick what the proper form is at this point. And then I'm going to have another question for Mr. Bernstein, but let me do the easy question first. Depending on what we, Kel? Well, this is actually a question for Patrick too. So, do we have the option if the petitioner requests, if the applicant requests of continuing this?
Yes, you do.
Get more information, perhaps you can get more information for us that might affect our recommendation. I just want to be aware of that before I say, what else I'm going to say. So having said that, I guess what we'd be looking for at this point would be a motion to agree to a set of recommendations or findings of fact, or I guess it would be a single recommendation, but comprised of findings of fact that if we can all agree, which would be determined by a roll call vote, that certain numbers of the standards have been met. There's one or more that we're still an issue about, and that could be the way we dispose of this today.
Yes, I would recommend, so let me see. Okay. So there's some that you say that the standards have been met. There's some that you say you're stuck on. I think it would be helpful to identify which standards the board thinks that they do meet, and that then for the next meeting, I can prepare the findings of fact to at least have that drafted and for the board to review. And then once you get more information, once I consult Corporation Counsel and we discuss a little bit on what the ones you're stuck on, then we can draft those at the next meeting, but we'll have half the work done.
Okay. Let me see if I can streamline that a little bit. Is there anybody on the board who would take a position other than Vice Chair Yablon that all of the standards have been met, but the one having to do with the proprietary interest? If so, please voice your opinion now.
I'm also not sure that it's in harmony with the spirit and intent of the zoning code.
Okay, good point.
But that in itself is a vague standard, but
And kind of relates to the proprietary interest standard.
yeah.
Okay. Okay. All right. Anybody else have anything to say on that?
Oh, and I also have if we were discussing it more, if this, it says unusual hardship, which is not generally applicable to other properties within the same zoning district, this would be a problem for all properties in the zoning district if there were contiguous ownership, correct? I mean, this is not aimed at them.
And they
So-
weren't grandfathered in or otherwise, yeah.
So this could happen to anybody, this kind of thing. If you,
But unlikely, because most of the houses have been there either pre-zoning ordinance or, you know,
I'm just saying, okay, so
are
let's suppose-
existing non-conforming, but yeah.
let's say I suddenly inherit tons of money, I don't know from whom, but I'll find that person. And I were to buy a house, and then I were to buy the house next door, and then I would tear down the house next door and then attempt to build on it, the same thing would happen to me, hypothetically.
If it was undersized, yes.
If it were undersized or just in general?
In general.
I think in general.
If it's legal on record, what does it matter?
Yeah, if it's.
Oh, that's true. So if it was a legal out of record, it wouldn't happen. So it's only happened because of these specific.
Because they're undersized.
Yeah.
So if it were an undersized lot, like say the end of Lincoln, it could happen. I'm just saying hypothetically.
Hypothetically,
I know.
the old anything's possible, but I think it's extremely unlikely.
But
Yeah.
what we saw in the presentation, 90% of the lots in this sample size are undersized.
So,
But for the legal lot of record, there are multiple standards. So there could be other issues where you have a problem with it being a legal lot of record. Undersized just triggers this. Is it, Patrick, is that correct?
Yes, there are 5 requirements. Let me pull this up. Okay.
How do you comfortably say something's in harmony if it deviates from the code? I guess that's my question.
It's a matter of interpretation. There's a certain amount of ambiguity there.
On purpose.
So it's squishy. Do you want me to read determining proof of lot of record?
If you want to, sure.
Or I think Patrick's pulling it up.
Sorry, there's so many code sections.
I think Alexis may already be at it. She already has it.
I took a picture of it earlier because I was getting so tripped up and everything.
Perfect.
So. Pull it up.
Okay. Yes, I have it on this computer, of course, but
I think Alexis can read the.
I can, I'm happy to read it.
go for it.
So, properties requesting relief from the zoning ordinance must meet the city's definition of legal lot of record. If the subject property is not a legal lot of record, a subdivision may be required prior to the issuance of a building permit. So, a lot or tract of land that meets each of the following requirements can be a legal lot of record. So, it's either A, part of a subdivision, the plat of which has been recorded in the office of the Lake County Recorder of Deeds, or B is a parcel of land separately described in a recorded deed, and 2, the lot of tract was created by either A, a plat of subdivision, or B, a deed recorded prior to May 8th, 1960, And 3, the lot or tract of land at the time it was created complied with all applicable ordinances and regulations. And number 4, the lot or tract of land was not created by the sale or transfer of property that resulted in either A, the creation of a lot or tract of land that did not comply with the lot area, depth, and width regulations applicable at the time of such sale or transfer, or B, the increase in the degree of nonconformity of any existing nonconformity lot or tract of land. And 5, if the lot or tract of land does not comply with requirements for lot area, then it must have remained in separate and individual ownership from adjoining lots or tracts and land continuously at all times since May 8th, 1960. For purposes of this requirement, a lot or tract of land shall be deemed to have been owned separately and individually from adjoining lots and tracts of land since May 8th, 1960, so long as the owner of such lot or tract of land did not directly or indirectly have legal title or enjoy beneficial interests in the lots or tracts of land contiguous to such lot or tract of land at any time after that date.
Thank you.
Yeah, thanks. Just what you wanted.
I just want to read, can I read one thing into the record?
If it's related to this.
It's related to some AI study from this. I just typed in, does an LLC member have proprietary interest in a property? And what comes up is an LLC, limited liability company, member does not have a direct proprietary interest in a property owned by the LLC. Instead, the property is owned by LLC as a separate legal entity. The members of the LLC have an interest in the LLC itself, not in the individual assets like real estate that owns the LLC. So I don't know what, take it for what it's worth, but I just,
That's
figured
that's very relevant. That's very
bring that
pertinent.
into the mix, yeah.
Anybody else have anything they would like to express at this moment? Kel, do you have any predilection as to anything you want to do before we try to dispose of this?
Well, I'm somewhat confused where we're at. I mean,
You're not the only one.
okay, so, and it takes a lot for me to get confused. So it's either one, we go to vote tonight. I'm pretty good at reading tea leaves. I can't read them tonight. The second is continue the matter, try to address the concern, it seems, of some members of the board with regard to standard number 4. With regard, I don't remember Chase mentioned standard number 2. I would just mention, and I'm not trying to re-argue the situation of the case, but it's not generally applicable to other properties from the same zoning district. I would think that'd be present conditions, not what, there's a lot of hypotheticals you kind of threw out there. I think we really have to be looking at, does it affect properties today, and looking within that lens. And with regard to the harmony and the spirit and intent of the zoning ordinance, the only thing I would say about that is that, and I think this was brought up, is that this area was subdivided in this manner, and there were houses on all of these lots for decades. And so with regard to the harmony and spirit of the zoning code, I mean, one of the harmony and spirit of the code is basically to preserve the neighborhood. And this neighborhood was contemplated when it was created. Again, this is even before my time. This is 1924. And so this was created with the thinking that there was going to be all kinds of small lots. And what would really change is the zoning ordinance changed, because it started creating, overlaying some additional rules. But if you go back to the intent and the harmony and spirit of the zoning code, it's basically to preserve neighborhoods. And this neighborhood had a house on the side, and this property had a house, and not only a house, it had a Van Bergen house on it. It had an important house there, and I asked the applicants, why was it torn down? And they said, the house was in really bad shape. It was falling down. I mean, it needed to come down. It didn't have the ability to renovate it. So it just took them a long time to figure out what to do with this property, and then we're here, it was 18 years later. And so if the board, if they're still struggling with standard number 4, I can look up, our AI and try to find out what propriety interest to, and try to get some more information. My whole position has always been that a member of an LLC, the LLC owns it, distinct from and that's what Illinois law is. Corporation Counsel has taken a different opinion as it applies to the zoning ordinance, but I don't know if that applies specifically to this provision regarding proprietary interest, because it may be different with regard to the interpretation for the purposes of contiguous lot ownership versus the way it's written and intended in this standard, in standard number 4. I don't know. Frankly, I've never had to deal with that question before, so it's an interesting issue to look at. So I think if the board wants more information, and I can obviously have a conversation with Corporation Counsel, I don't know the telephone number, I could call them and see what they're thinking on this, but I appreciate the thoughtful discussion, because again, this is something, this is not your normal case that you hear, and I appreciate your thoughts. So if you feel more comfortable with try to get more information about that standard, I'm okay continuing to the 4th. I'm going to be here that night anyway, so it's up to the board.
Okay. Yeah, I personally, while I understand and I think it's relevant what Brad researched on AI, it still doesn't necessarily, in my mind, definitively answer whether allowing this to go through would be circumventing the zoning code. Whether just because say, okay, well, geez, legally, if you own an LLC and the LLC owns property, you don't have a proprietary interest, then that kind of is doing a little bit of a sidestep around the zoning code.
But every variance you granted, you could say is circumventing the zoning code, because if you grant side yard relief or rear yard relief or front yard relief, I mean, you're trying to get around with the exact, because you shouldn't be, I would respectfully say, I wouldn't use the word circumvent. I was asking for relief, does it meet the standards? Because you have the ability to grant variations to circumvent the code if you feel it meets the standards.
Right, except in situations where someone is intentionally doing another, again, being repetitive, an intentional act in order to circumvent the zoning code. I think we probably have a little bit more.
No, I don't think the affirmative act, I think the term of art has created the hardship. And I think that's what we really need to look at was there a intent to create a hardship? It's basically to create a hardship. And that's what that standard says.
Well, but is that a strict liability standard, or is it if the intent isn't there, then it doesn't apply?
I think
Member Weisberg wrote that up.
I think you kind of have it's up for interpretation. I don't think it's specific. Just like any other, every other application you hear, I mean, is a strict, you wouldn't grant any variations if it was strict liability. You adhere to every single standard, every single word to every standard. I mean, you do take some liberty with that, and rightfully so, because again, this is, it's a quasi-legal, but it's also equity. And you're trying, it was brought up, is that, you're trying to create a situation that, you don't want it to do something to the detriment of someone who bought a house for $380,000 thinking that they could build on it. And I get you're in a tough situation. Your job is to apply the standards. My job is to try to persuade you that the standards are met.
So the question then is going to be, we can re-poll the board, but I still would feel more comfortable having Corporation Counsel weigh in and get some more information before making our recommendations. So,
okay.
I don't know how.
And just to say,
I'll pull myself first and ask if anybody.
I would just say is that, and I agree with Patrick on this one. Corporation Counsel is just advising you. They're not making the determination. You have the job to make the determination. So if the Corporation Counsel comes and says, hey, it doesn't mean you have to say what you have to agree with Corporation Counsel. Otherwise, the Corporation Counsel will be the zoning board rather than you guys. So I think that that's just a resource for you if you want to get some advice from the Corporation Counsel.
I would like to avail ourselves of that resource, yeah.
Yes.
I actually have a separate.
Sure.
Patrick, in 2008, after that letter was sent out saying we see it as being one lot, was it sent to the good people property tax? What happens on that front?
What was your question?
It deals with property tax, like if they're saying it's.
They could use that to go to like county and say, hey, this is an unbuildable lot, and then they would get a cut on their taxes. That's something that has happened in the past with other properties. I don't know if that's something that they did or not, but that's something that you could, because this is an official determination letter sent by the city and saying that this lot can no longer have a single family house on it, so it wouldn't be taxed as it could.
And also, if it was determined that it was one piece of property, I'm assuming the taxes on the property that had the house on it would have gone up additionally.
Well, so they're still
because it
two
would be a
separate
lot-
parcels, so they're not,
There'd have to be a lot consolidation for that ever to affect the taxes for the property as a whole.
Okay, just trying
I
to,
would note that it was, and I would have to verify this, but. Okay. I'm trying to identify that song, but I'm drawing a blank. So the, I kind of lost my train of thought. No, I could pretty confidently say that when the house was demolished, then the property tax was they were being taxed on land only, but it was a separate PIN number. So taxes were being paid separate for this property. It was not being taxed with a structure on it, since the assessor would have picked up the demolition. But there was nothing with regard to going to the assessor saying this is one lot, because it wasn't one lot. It was always two separate lots. When the structure removed, the improvements removed, and so therefore you're not being taxed on the improvements.
okay.
But again, as I was advised, the house was in bad shape, falling down, and it had to be come down while they were deciding what to do. And then obviously, when you look at that 2008 letter, it really frankly didn't make a lot of sense, that they were the trustees of a trust that never existed, that never held title. So really, nothing ever happened after that, because it really was, I don't want to say nonsensical, because I don't want to, but it just didn't make any sense. It's another way of saying it.
Anything else at the present time? All right, I think we
What do you recommend?
maybe kind of have an idea. I would recommend that I would entertain a motion, perhaps, well, I'll tell you how I would vote to continue it and get some more information and the Corporation Council.
Mr. Chairman, if you could just help me narrow the issues where you want me to come back and talk to Corporation Council and try to, but I don't have to go through this entire presentation, because I know you're glass-eyed over this anyway, so
I think I can only speak for myself, and then we'll give an opportunity for anybody else who has anything to say. But for me specifically, I'm concerned about if we just ignore the alleged hardship has not been created by any person presently having a proprietary interest in the subject property, are we kind of flying in the face of Corporation Council perhaps taking the position that we are allowing this to circumvent the zoning code?
Okay,
So that's the primary issue for me. I don't know if anybody else has other issues. No, I don't. Okay. Vice Chair Lee? Yep.
I still have big issues with the last standard in terms of harmony and spirit of intent with the zoning code.
Okay. You got that as well? That's question. Okay.
Harmony spirit.
Okay. All right. I would please entertain a motion at this point.
Vice Chair Yevon makes a motion to speak with, to postpone, what's my motion? To continue until the February meeting, is that your choice? The February 4th meeting?
That's the next scheduled meeting?
February 6th.
Wait,
I'll second. Members Ransky seconds.
Okay.
Okay, so we've got a motion. What?
It's the next meeting. It's the first Thursday of February.
Okay, so we've got a motion by Vice Chair Yablon to continue this to the February 6th meeting, which is our first zoning board meeting in February. And was seconded by Member Zoransky, and that would be without further notice. Patrick, may I get the roll call vote, please?
Yes. Okay, Member Weisberg? Member Wolf?
Aye.
Member Chase?
aye.
Member Zoransky?
Aye.
Vice Chair Yablon?
Aye.
And Chair Bang?
Aye. Okay, motion passes 6-0 to continue this until February 6th. We will see you then.
I apologize, you're going to get 2 cases from me that night, so. I try not to do that.
All right, before we leave, we do need to adjourn.
I apologize. I knew around here.
I understand you're in a hurry. Okay,
I
so-
move to
and actually-
adjourn.
Well, okay, first I have to go through the formalities, guys, you know.
We have to go
there's-
through
There's a
that.
reason one of us is chair here, for goodness sakes. All right, so number 6 as the next item on our agenda, which is staff report. Patrick, do we have a staff report?
We do not have a staff report, but just speaking on for the next meeting for this item, come to that meeting, because we will have to draft the findings of fact, and we have to be specific on the verbiage of what the findings are. I provided just a template of just approval. So if you find some of those satisfactory, we don't have to change any, great, let me know. But then if you find verbiage that you would like to change, and that's what we will be providing to City Council. So just come prepared to that meeting for finalizing these findings of fact, and then I'll go to Corporation Council on the proprietary issues, and we'll go from there.
Fair enough.
But that's all I got.
All right. Anything under item 7 miscellaneous? Seeing nothing, we will move on to item 8 adjournment. I will entertain a motion, please.
I'll move to adjourn.
Second.
I took it.
Second. Okay. Motion. Member Chase to adjourn, seconded by Member Zaransky. All in favor, please say aye.
Aye.
We are adjourned.